We are going to start in just 1 or 2 minutes. I'm going to give the last folks a chance to come back in before we dive in. I agree. It's the fatal flaw of the design.
Very bad flaw. It's been half my life looking for this.
Oh, there we go. Okay, I think that's all of us. All right, we might have some additional members filter in, but for the purposes of our business today, I think we'll go ahead and get started. So today is Friday, September 8th. It is 11:53 a.m. This is a work session regarding findings of Municipal Ombudsman's final investigative report concerning April 11 election complaint and creation of ITD policy statement regarding removable storage devices. We're scheduled here till 12:50. We have a little wiggle room at the end, but not a lot. Why don't we go ahead and do introductions?
George Martinez. Felix Rivera.
Karen Bronga.
Scott Myers.
Anna Brawley.
Meg Zalatow.
Christopher Constant.
Randy Sorp.
And on the phone, we have Mr. Johnson, right? Anyone else on the phone? Not hearing anyone else. Thank you. Okay. Thank you, everybody, for attending today. This is the second work session on the topic of an election complaint filed on April 11th by election observer Sammy Graham in coordination with the creation of an ITD policy by Director of IT for the municipality, Mark Dahl. For background, 7 weeks ago, we met on July 21st because a concerned citizen filed a report with the Ombudsman, who began an investigation into the circumstances surrounding the April 11 election complaint and an internal municipal policy statement created by the administration used as the basis of the complaint to overturn the outcome of an election. The Municipal Ombudsman published the final investigative report on Friday, August 18th. A copy of the report is included with documents for this work session, along with all other documents we will touch on today. We are here today because the Ombudsman's findings have alarming implications for our local elections, and the public deserves to know the truth. As the Assembly, we have a special interest, a directed interest in this report because we bear a charter-bound duty to author a strong code that protects our nonpartisan elections. Our conversation today is about understanding the facts so that we can fulfill our duty. Seeing as they were named in the report, we invited Mr. Dahl and Ms. Graham to the work session today to speak on the record about the circumstances surrounding the April election complaint, the ITD policy statement, and the findings of the final investigative report and the recommendations included therein. A representative of Mr. Dahl responded to our invitation in writing that he would not be in attendance. We did not receive and have not yet received a response from Ms. Graham. It is unfortunate that Mr. Dahl and Ms. Graham are not here today to provide their accounting. However, I'm asked to caution all members not to construe their absence as evidence of wrongdoing because our Fifth Amendment to our American Constitution provides individuals a right not to incriminate themselves. That said, we'll continue today so that the Assembly can adhere to its duty to safeguard municipal elections. Can we get the slide presentation up, please. All right, can we go to the second slide? Mr. Hess, the Ombudsman. So I'm really grateful that you're here today, Daryl, to help us to understand your report in this work session, so members of the public can have a briefing on this matter. So to begin, I would like to allow you to present your findings.
Thank you. I appreciate the invitation. On April 26th, the constituent contacted the Ombudsman's office following the April 20th Anchorage Election Commission's public session of canvass and adoption of the election canvass report. The constituent was concerned about a lot of things that were statements that were made during the commission's meeting, comments made by complainants, allegations involving an alleged municipal policy that staff seemed not to have been aware of prior to the complaint being filed. So I opened an investigation. I reviewed over 1,000 pages of documents as part of a public records request. And I will note that the records that I received were not redacted, as were the records that were provided to assembly leadership and members of the media. So I was able to review unredacted records. I also interviewed multiple municipal employees, former municipal employees. I viewed surveillance videos from the election center. I looked at photos, reviewed photos pulled from those surveillance videos. I looked at the sign-in sheets for the election center. It was a fairly extensive investigation. It took me a little while to go through all the evidence. And what I determined was that a lot of organizations do have policies regarding the use of USB thumb drives. For a lot of organizations, they consider it best practice to have thumb drives scanned before they are used. The municipality's IT department has had, across multiple administrations, an internal department policy regarding the USB thumb drives, but we have never had a muni-wide policy. Last fall, in fall of 2022, the IT department started discussing the possibility of creating a muni-wide policy regarding the use of USB thumb drives. That conversation went dormant in January. In March, the IT director, Mark Dahl, requested information from the Muni's records coordinator regarding P&P 1-1, which outlines the process for creating Muni-wide policies. And she provided him with a link to that policy. So the IT director was aware of the requirements of establishing a Muni-wide policy in March of 2023. Suddenly on...
Mr. Hess, I'm sorry, was slightly distracted. Would you say that part again?
So the IT director was aware of the requirements of P&P 1.1, which outlines the process for creating municipal-wide policies. He was aware of that policy at least as early as March 2023, when the document link was provided to him by the Muni's records coordinator.
And the records coordinator is?
Anna Plant.
Thank you. And was that in an email?
Yes.
Thank you.
So the conversation had gone dormant in January, and then suddenly on the morning of April 11th, the IT director contacted the IT department's Chief Information Security Officer. I had to get that, make sure I got it correct. Contacted him and reinitiated the conversation about creating this policy. They exchanged several emails. And the previous iteration, the internal policy, did not reference critical infrastructure or transferring data. The director, Mark Dahl, requested that that be added to the draft policy. So language was added to the draft policy. And then that same afternoon, the director asked that that finalized policy be posted on the municipality, the IT department's intranet page. So a new policy page, security policy page was created for IT and on their intranet, which is not available to the public. It's not the intranet, it's the internal intranet. And the page was created, the policy was posted at 1:28 p.m. on April 11th. At 2 p.m., Mr. Dahl emailed the posted policy and an intranet page link to himself from his Muni email address to his Muni email address. And then at 2:37 p.m. from his Muni email address, he had cut and pasted the policy, put it in the body of the email, and also included a link to the intranet page. And he emailed them to Sammy Graham at 2:37 p.m. on April 11th. At 2:34 p.m. on April 11th, the same day, Sammy Graham had signed in at the election center, sat down, met with a couple of other election observers from the True Blood campaign. They discussed the form that she had in her hand. I've seen the videos, seen the photos, did some writing on the form, and then they submitted that election complaint. So she signed in at the election center 66 minutes after the policy page was created and the policy was posted on the intranet, not on the internet. So it was not publicly viewable. Only 3 municipal employees were aware of the policy. Yet she cited that policy almost word for word in the complaint that she filed that same day. And I know the next day I saw videos from the election center of Mark Dahl arriving at the election center, picking up one of the other election observers. They left, and then he dropped them back off about an hour and a half later. So he obviously was acquainted with at least 2 of the 3 individuals who filed the complaint. So when I looked at this, it's just about connecting the dots. It's troubling that an individual was aware of a policy that had been created that very day. And so in my mind, it appeared, based on the available evidence, that the director may have insisted that that policy conversation be restarted and the policy be finalized and posted that day to assist Ms. Graham in filing an election challenge.
I would note that about 10 minutes ago, Mr. Cross and just now Mr. Vaughn have arrived and joined us. So are there any questions for the Ombudsman? Ms. Brawley.
Yeah, just a clarification. So you said the policy was not available or it wasn't public. And you were referring to the intranet, is that right?
Correct.
So are policies normally, for example, viewable or searchable to members of the public? Like if I wasn't on the assembly, I was just at my house and I wanted to look up an internal muni policy, is there a way to do that without making a records request or requesting it?
You would have to request it or make a records request. They're not
Okay.
viewable. The P and Ps, those that go through the required process that are muni-wide, are available online.
All right, thank you.
Anyone else? Mr. Salt.
Thank you. So just a couple of questions. So I guess, is the policy on putting thumb drives in Dominion machines or any machine a good policy?
I don't think that's a question for the ombudsman. I think it's a question for our
Okay.
election staff. The ombudsman is not an elections worker.
Okay, I'll go to my other ones then. So do you have a link of Mr. Dahl providing the policy to Sammy Graham prior to her making the complaint? Not an opinion, a link, a physical
So
proof.
she signed in at the election center at 2:34. He emailed the link, the information to her at 2:37. But on the videos, you can see her looking at her phone.
And when was the complaint filed?
The complaint was filed after 2:37.
Okay,
She signed in, she sat down at the table with two other election observers. She looked at her phone and they were making edits to the form.
okay. And the history of the policy, kind of the inkling of it being created, started in 2022?
So the discussion started in 2022, went dormant in January, and Mark Dahl restarted the conversation on the morning of April 11th, 2023.
Okay, thank you.
And I will note that the Chief Information Security Officer did note to me that there's no way that policy could be enforced outside of IT, that it was not intended to be anything at that point when it was posted on the intranet other than an internal IT policy. Because they have not, one of the things that's required for a P&P that has muni-wide applications, every department director, every department records coordinator has to be involved. OMB takes lead on it because you have to include the procedures on how you would implement it. And the Chief Information Security Officer told me that they had no way how they would implement it. So it was, at that point, it was not intended to be muni-wide. It was strictly an internal policy.
And I believe that we all have been provided with a copy of PNP number 1-1, Policy on Policies, which states the process by which this is done, which has been in effect since 1997. And we heard today that Mr. Dahl was notified in March of how the policy works, its existence, et cetera. So that is definitely an area of inquiry. We'll hold your question for the clerk on the USB drive until we get to that. So
I do want to make one other comment. I did not include this in the report, but an IT staff member did tell me that they cautioned Mr. Dahl about sharing that policy and link with Ms. Graham, that they thought it was inappropriate and advised him not to do it.
So, Mr. Hess, I want to ask for a clarifying question. You just said a few minutes ago that you were told by the Chief Information Security Officer that that policy couldn't have been intended for muni-wide application because it's an internal policy. But does it appear to you, or does the record reflect that it was used as it purported to be a muni-wide policy?
That's something that also I found troubling, was if the director is going to share it with a member of the public, the director should have been very clear that it was only an internal IT department policy. Sharing it with a member of the public and them using it to challenge and potentially try to overturn an election was even more troubling, because he was aware it did not have muni-wide applications, And notwithstanding the provisions of the elections code, which gives the IT, authority for IT decisions to the election administrator, it couldn't have been applied to the elections team because it was not a muni-wide policy.
All right, thank you, Ms. Brawley.
Yeah, thank you. And I think this is along the same lines, but I think what we're trying to establish is, or confirm is that policy was not legally in place. So I'm thinking of, for example, an ordinance becomes law after the assembly has voted to approve it, right? And so policy does not have that same procedure. And so it's not a question of whether the policy is good or not. It's whether it was in place. And so my specific question is it correct then that in order for it to be a muni-wide policy, it's gone through this process and then OMB has essentially approved it and put it into place? Is that correct?
Correct.
And so OMB has not taken, by April 11th, 2023, OMB had not formally approved this policy.
No, I actually, I contacted the OMB director and I contacted 4 department directors. None of them were aware of the policy. And the directors were pretty shocked, the department directors, and one of them asked me who they could contact to complain because they said, we can't make this work. We use USB thumb drives on a daily basis, and there was no procedures that went along with it. So that director wanted to complain, and I said, don't worry, it's not muni-wide. It's not enforceable.
So again, just to be super clear then, it sounds like this policy then was to use an analogy, maybe the equivalent of a draft ordinance or a draft policy. And so it may be applied in one department, but in terms of it being a citywide policy, the steps had not been taken to put that into place. Is that correct?
It was a policy that was in place for the IT department only, but it could not be applied muni-wide. You are correct.
So essentially, the election staff, the clerk's office, that policy did not legally apply to them at that time.
No.
Other questions for the ombudsman? Ms. Branca?
So I'm not sure I completely understand what my opponent, she met with me and said, if they just would have shown the thumb drive, we would know there was nothing on it. But they wouldn't show the thumb drive, so that obviously means something was wrong. Was someone trying to review what was on the thumb drive that was being moved around? Do you know?
So that's, I think, a question for the elections team, but I will say during my inquiry, the elections team pointed out that they offered to allow the observers to compare the numbers on the computer screen to the numbers that were downloaded from the USB drive, and they declined.
Thank you. Other questions? Mr. Martinez?
Just a comment. I have previous experience working with other members of a previous administration on a PNP for language access, for example. And that is an incredible amount of work. And I just want to just raise to the public, to move a PNP, a policy and procedure across muni-wide, takes an incredible amount of work, incredible amount of due diligence, and it's because of the importance of those policies and procedures that you have all of these checkpoints. And so there's a lot of vetting that goes on, and I just want to be clear, none of that is what we're talking about. That did not happen in this case at all, and we're dealing with an internal intranet shared policy that essentially is was framed as a muni-wide or acted on like it was a muni-wide PNP.
Correct. And this PNP 1-1 has been in place since Mayor
96.
Maestrom was mayor.
Right.
And there's a reason that we have this process, because if it's going to be a muni-wide policy, we have to ensure that it's workable for every department.
That's right.
That it's not going to cause more problems than it's going to solve.
And let's put a fine point on workability. Workability in operations, but it goes through OMB because there's also costs associated with changing the way we do business and the protocols within a department. And so when we talked about language access, we knew that there were going to be costs that we had to really talk through. And it took a lot of due diligence, a lot of meeting with directors, and a lot of just convening to get on the same page. I just wanted to be real clear that PNPs are not something light. The policy and procedure to move a PNP forward has been in place since '96. And there are a lot of checkpoints so that we have really good policies and procedures that have been vetted by mostly everybody.
Correct. And I will say, IT, there is another draft PNP that they have been working on for about a year. It is a long process.
So I would just jump in there and say that the workability factors beyond cost, I can assure you that folks in the legal department, the prosecutor's office, the defender's police department, they're not going to allow a member of the IT staff to monitor every flash drive before they put them in or out of a computer. And so practically speaking, it was an absurd policy on its face that didn't meet the functionality of the departments. And so I think that's it's money and it's practicality. Is it actually doable? Okay, so thank you again, Mr. Hess. You can stick around, you can step down. Can we go to the next slide, please? So here we have a couple of screen caps of the actual complaint. I want to draw your attention to two things first. One is that the title of the form is Election Commission Failure to Comply with Law or Alleged Illegal Election Practices. And in fact, the section on the next page in highlight, it says an explanation of how the concern would change the outcome of the election if found to be true. That's an important fact for people to understand. The allegations were made, not just that there may be a problem, but they believe that a violation has occurred sufficient to overturn the outcome of an election if found to be true. So that's the basis of the complaint. So for the public's understanding and my colleagues, I want to put a fine point on the core issue and what makes the findings of this investigation so severe. An election complaint is a tool for candidates to raise legal concerns about the administration of an election. As I read the title of the form, Election Commission Failure to Comply with Law or Fact or Alleged Illegal Election Practices, observers complete the form by stating an explanation of how the concern could change the outcome of the election, and Ms. Graham, in fact, signed her name to the complaint twice. So let's be clear. The purpose of an election complaint is to challenge the outcome of an election. Next slide, please. We would note that the Ombudsman's investigation found that the mayor's appointee directed the development and posting of a policy to provide support for the impending election challenge. That this policy appears to have been designed to support an election challenge. Next slide. Actually, can we go back to the previous slide? I want to point one thing very specifically out, is that the language of the ITD policy statement is exactly the language quoted in quotes in the complaint, verbatim. They're the same. So that is clear evidence of coordination. We know that the information came from Mark and it was transcribed directly into the complaint. So now the next slide. Interestingly enough, if you look at the origin and kind of trace back through the communications we've had with the administration, the mayor himself raised questions about using USB drives in a request for a quote forensic audit of the 2022 regular municipal election last year. So what we have here is a thread of public records that demonstrate a concern over the same issue. One is a formal request from the mayor. The second is a policy statement that's applicable to the IT department. And the third is a complaint that says that policy is germane to the municipality as a whole and the election specifically, and thus sufficient to overturn the outcome of an election. Please, Ms. Zalatel.
Thank you. Mr. Hess, I actually have a question kind of based on the timing with these documents. So the first time we're hearing about this USB concern is April 29, 2022. Would that have been, in your experience, sufficient time for the mayor to have instituted a formal policy process to take up the USB question in order to have something in effect prior to the administration of the next election?
I think there would be a good chance, based on my experience, that you could have a PNP in place, 10 or 11 months later.
Okay, and based on your investigation, you didn't see any initiation of a formal process, is that correct?
No, there were conversations in fall around October 2022. They were really focused within the IT department.
Okay, thank you.
All right, so I guess next slide. Again, we as the Assembly are bound by the charter to protect our local elections by authoring a strong code. In order to do that work, we need the facts, and the public deserves to know. Since our last work session, Assembly leadership requested unredacted documents from the administration. We sent the request to Mayor Bronson on August 18th with the required production date of August 22nd, our last regular meeting. And as of today, those documents have not been provided to us, and no direct claim of a deliberative process privilege has been asserted. It has only been suggested that it may apply. But those records have not been produced, and a month, no, 3 weeks have passed well beyond the 10 days of a public records request, and reason would demand that these records be provided, or at least a statement be provided of the status of those records. So there's more evidence that the administration is not producing and providing records that are required for the Assembly to move through its process of understanding the effect of these claims on our elections and how to protect our elections from abuse in the future by coordination with members of the mayor's administration and members of the public who have decided they want to attempt to interfere with our elections. On September 5th, we issued another request for a more broad set of records between April 1st, 2022 and May 1st, 2023, containing keywords such as elections, USB, thumb drive, and Dominion, among others. We requested to receive those records in advance of our regular meeting on September 26th. We did receive a response from the administration that the request was too broad, and so we are now in the process of effectively narrowing the request by identifying specific individuals rather than just unnamed employees who we would like to see the records from. So there is more to come. But in the meantime, our annual process to update Title 28, our elections code, which is established to operate fair and transparent elections and to protect our elections from abuse, is underway. This is a perfect opportunity to bring forward code changes that reflect what we're learning about this event. With that, I'd like to open the floor to Assembly members to discuss what options we might consider in resolution of this issue. Thank you. Ms. Zolotel.
Thank you. So the policy issue is one that I think is really akin to us not making changes to the election code after an election contest is moving. So we do our annual update of Title 28, and that's always completed before the end of the year because after the first of the year, an election contest is on. And so I'm really interested, although I don't know enough yet, to possibly suggest a code change that says any policies also would be restricted from being implemented that would affect how we do our elections after an election contest is on until such time. So it would coincide like with our code changes. But I have a couple of questions, and unfortunately, Mr. Dahl and Ms. Graham aren't here to ask them, but I'll go ahead and ask them anyway. I think the first and the major question I have is, did Mr. Dahl create and post the policy at his own impetus or at the direction of the mayor? Because this really gets to whether or not the policy creation was coming from the mayor's office, which is how policies are usually brought through that are going to apply municipal wide. And knowing that, particularly given the prior correspondence from the year before in 2022, I would want to know more about why that wasn't pursued officially, and then why Mr. Dahl, either did this internal policy that applied only to the IT department. There's just a lot of questions surrounding how we got to where we got with this internal policy. And I would like either Mr. Dahl or frankly, the mayor to tell us about their involvement in that creation. And similarly, I would like to know at whose direction was Ms. Graham given an intra-departmental policy. That doesn't seem to be a common practice. And so who knew that it might be used for this purpose, or did they know it would be used for this purpose? I find both of those things very concerning, but things that could have a legislative response, particularly around how policies intersect with the elections process. I did want to note, while we did invite Mr. Dahl and Ms. Graham, the administration, including the mayor, pretty much have a standing invitation to come to work sessions, and often do through the chief of staff and the municipal manager, which were here at the last work session on this topic. So I would really like to also hear from the administration, specifically the mayor, what he knows about this, because I think that is a key piece to ensuring that we can legislate appropriately between the branches of government and know where the separation of powers lie, and ensure that we don't have an inappropriate interference with our elections. So unfortunately, probably no answers to those questions today, but ones I wanted to raise as we think about future legislation. Thank you.
Ms. Brawley.
Yeah, thank you. And I have not yet gone through an annual review of Title 28, so I can't offer specific suggestions or recommendations, but I think I'm still stuck on the fact that, you know, and this is going to be a rhetorical question, but how does an employee violate a policy that doesn't legally exist? I think that's the question. And so it's hard for me to see a legislative fix to this, because I think fundamentally and it's not whether the policy is good or not. It's not about, you know, how one would implement it or how much it costs. It just fundamentally did not legally exist or did not legally apply to the department to which the complaint was alleged against. And so, again, I don't know a solution to put on the table, because I don't know that that's the problem. I think it's fundamentally that the basis of this complaint was flawed. And then following on to that are all the questions about what was the motive or the intent for this action, which I think we've been digging into.
Thank you. Mr. Salt.
So just, I guess, a point of clarification, and I agree. I don't think I'm not sure the policy was in place, but I haven't seen the initial internal policy. But what I do see from Mr. Hess's report, that initial discussion around the policy that took place in fall 2022 has the same language that Ms. Graham put in her complaint. So technically that leak of information, whether it's proper or not, could have occurred anytime between fall 22 to April 23. And I'd like to compare the initial internal MOA policy to see if that language also matches that might have been available. Because I think we're trying to make a link that Mr. Dahl shared it that day, and I'm not sure that's a safe link to make. And if someone's going to take action, we got to be right. Thanks.
Mr. Hess.
The major difference between the policy that was discussed in the fall and the one that was finalized and posted on April 11th is the item number 2. So if you look at the policy, there's 1 and 2. So that second bullet point, the second point in the policy that was posted, refers to critical infrastructure and I think transfer of data. That was what the director, Mark Dahl, requested to be added to the policy on April 11th. So that's the major difference between the policy that was discussed in October 2022 and the final policy that was posted on April 11th, is that second bullet point was added to the policy.
Thank you.
And I would note that you have a little white binder, which is the records from the previous work session. And there are all of those black pages in there. And it is by no fault of our own that those records are not before us today. We have requested them, and they have been denied us de facto, and they have yet to be delivered. And that's a matter of concern for us going forward, because you raise a fine question. Maybe there is some form of reasonable doubt that exists within the previous communications, but without that information, the record is what it is. And so
that'd be helpful. Thank you.
Mr. Bolland.
Thank you, Mr. Chair. That kind of gets to where I wanted to go. In your prompt for this portion of the discussion, I think you kind of were asking, where do assembly members want to go with this. And I think that that information is crucial. And I guess I would ask, what are our tools, that the assembly leadership can use on behalf of the body to get that information?
So this is when I turn to Assembly Council, Legislative Council.
Thank you, Mr. Chair. Member Vol and through the chair, the steps that we've gone through in the past were once we've been denied something through the public records process, which again, I don't think we have a definitive yes or no on that question. The initial request for the unredacted documents was made as a public record request, but subsequent steps could be to at least request its production in executive session if there's some problem with producing it as a public record that the administration could identify to us, or we could follow up with a subpoena. Although, however, based off of previous history, I think we know that the bases for denial of our public records request or production of something in executive session would probably be used as a basis for denial of a subpoena, and that would leave us with several options, almost all of which go through the court to compel production of the documents that we believe we're entitled to see.
Okay, I appreciate that. If I would just follow up to say that I think this is something of, on the magnitude of which we need to use the tools that we have. And for my part, I would encourage assembly leadership to, offer maybe an executive session, and if we still don't have access to that information, to issue subpoenas.
Yeah, so, and the process by which we do that, I was tuned out for a minute if Mr. Hurt suggested the process, but the process would require assembly action.
Yeah, and that happens quite frequently when lawyers speak, so my feelings aren't hurt. But yeah, the process by which we would have the authority to issue a subpoena would require resolution by the assembly to grant the chair that authority.
Thank you. Yeah, I didn't tune out because I wasn't listening to something, but okay. Other members, Ms. Alatil, you're in the queue.
Thanks. So on the deliberative process privilege, it was what was claimed for the blacked out documents. And I know leadership sent a letter on August 18th, 2023, disputing that claim of privilege, at least as broadly as it was applied. Have we received any response to our concerns or a refined set of records since that time?
As of this meeting, Vice Chair, no, we have not received.
Okay. Thank you. So to me, that kind of cautions going into an executive session. I would really only want to go into an executive session if we knew we were going to move forward. We've kind of tread this ground before. And I think we have quite a time crunch, quite frankly. If you kind of take a look at the calendar and the set of meetings we have left for this year, causes me a bit of anxiety. But if we need to make Title 28 changes, we need to kind of know the facts no later than around Thanksgiving, because that then gives us a very short window to create any additional code changes to introduce for the first meeting in December to pass at the second meeting of December. So we are on a time crunch. And I don't need to remind the members, but maybe the public, in the middle of that is the budget. So, I think we need to think carefully about the tools we have at our disposal and where we're trying to go, because we do have very limited options to try to get the information, or we'll just simply run out of time.
And to put a little point on what she means by time is that the election notifications start to be published after the first meeting in January. And so after that first meeting in January, until the election is concluded, there are no potential changes to the rules of the election. And so that's why our annual election Title 28 review happens before the end of the year, is because annually we begin an election in the first meeting in January. So that's the pressure of time for any resolution to this question that's legislative. So I have Mr. Cross in the queue.
Yeah, and I guess I would support the executive session because really what we're talking about as I go through this is it really comes down to a significant part on what the motive is. Because one, either there's a coordinated effort to create an elections challenge where no reasonable one previously existed, or there was an effort to reveal a significant concern regarding the security of our elections and a lack of a policy that adequately protects our voting machines from external hard drives. So which is it? That's motive. In which case, if it was, if that policy is flawed and we've got something that puts our electronic machines at risk, then that seems to me like bringing that to attention is more of a whistleblower than somebody trying to create an issue. And I guess I would really like to go into this because it just points to me the alarming vulnerability of our electronic election machines. If people can just insert, what does that policy look like? And
So I'm going to interrupt because you've just made some pretty extraordinary allusions and ask again, the elections clerk, the clerk, not the
well,
elections
these are
clerk,
an extraordinary circumstance.
to explain the security protocols that are around the flash drives, because that argument is in fact the argument that has been breathlessly touted, but it is not based in fact. And we've heard it a number of times, and they continue to argue it, but it doesn't match with reality. And so, Madam Clerk, would you please detail the reality of the security of the USB drives in the election center?
Sure. So it's my understanding that the thumb drive was obtained prior to 2018. It was obtained from the IT department as a scanned thumb drive. It was formatted and encrypted at the time. It's my understanding that the IT department had a lab and that they needed this lab at the time to do these things. Since then, it has been stored in a locked safe. Since 2018, it is in the election center. It is in a office which only the core team has access to with a cipher code. And it is stored in a thumb drive, or not a thumb drive, it's stored in a safe that needs a thumbprint to get into, and only the core staff have access to that safe. During a live election, the IT department trained our staff, and it's my understanding he did so because they didn't want to get a phone call while they were on vacation that something was wrong with it, so they trained us how to reformat it, and because that can be done now in normal computers, and so we were trained by the IT department to reformat them. We do it. We reformat them every year. And during a live election, it is required that two people check out the thumb drive. Like one person has access and can get in, but a second election worker has to go with them. And so the one who gets it out of the safe signs it out, and then the second worker with them signs along with them. And then when it goes back in, they log the time, then it goes back in, and it goes back in. And they both sign, then it goes back in.
I'm going to raise this question up a level. You're in the technical details of how, but there's actually a principle at play here. And the principle is communicated to us by CISA, the Center for Information Security, which is the federal agency that addresses these concerns. Can you kind of take us through that level of the conversation? Because we could go nuts and bolts over the mechanics of how the internal IT process works for the election center, but really there's a more fundamental question.
Sure. It should be addressed from the standpoint of which entity is authorized and accountable for MOA election data and integrity. It's defined in the charter and the code as being under the purview of the assembly and the clerk's office, and that it falls to us to safeguard election data and systems and process integrity by appropriately managing and monitoring access by all parties to election data and systems, and all requests for access to election systems and or data needs to be weighed against the requester's legitimate authorized need to know for the data in question. And if it's determined that the requester does not have a justified need to know, that the request should be denied to prevent risk to the election.
So the fundamental at play there is The fewer hands in the pot, the less likely you're going to have trouble. And the charter and the code grant that authority to the election staff who swear an oath to uphold the integrity of the election. And then we have the municipal IT director who, among other things in the ombudsman's report, has been observed taking lanyards he doesn't have the authority to have in order to participate in parts of the election process he doesn't have authority to partake in under the rules that exist, and also is crafting policies that are being utilized in a manner to make it appear that the election was fraudulently conducted, right? And so that's almost indisputable. I don't care about the motive. The why isn't the important question, it's the what. But the reality is the code, the charter, and the federal government's IT recommendations are as few hands in the pot as possible. So I have Mr. Martinez in the queue, then Mr. Hurt, then Ms. Bronca, then Ms. Brawley.
Thank you, Chair. I have a question about just first, there seems to be several different types of redacted documents in this that seem beyond communications, and I'm just curious of, can we have a little more understanding of what other documents are redacted in this particular binder? It seems like there's some PMPs redacted. Am I missing something?
Mr. Hess, you want to take that? I mean, I believe they're draft versions of the PMP, proposed PMP.
I believe they were redacted. I think the assistant municipal attorney who reviewed the documents is here. My understanding is, and from looking at the
Mr. Hess, I want to interrupt. The vice chair just asserted, and I believe she's correct, that these questions should be answered by the municipal attorney. We keep putting you in a position to answer questions for other departments, and it's not fair, Mr. Hess.
Jessica Willoughby, I'm an assistant municipal attorney. The question as to the redactions in the binder, when I reviewed the records, I prepared a privilege log that details each page and identifies what exemption the municipality was claiming. And so I can't do off the top of my head, but from what I recall, draft policies, procedures, that is policies that are actively being worked on and potentially, it is inherently a policy decision as to what that policy will be. Yes, I redacted under deliberative process privilege.
So I'm going to interrupt there before you follow up. Are you now stating it is no longer they may be subject to the deliberative process privilege? You are stating that they are subject to the deliberative process privilege.
I'm not interested in getting into a semantic argument about whether they may or they are. I think in the privilege log, I asserted the privilege.
No, you
That
said they
privilege can
may.
be
You said
waived.
they may. That's the language that I read in there. These may be covered under the deliberative process privilege. We never got a definitive answer, and I would welcome that.
We can go back to the email. I don't want to trip myself up in what I emailed. My memory of what I wrote is that I'm asserting this privilege. It is held, my understanding is that it's held by the mayor's office and that I had not had the opportunity to review each and every record.
Okay, so I think then we'll conclude whether the email says may or not. Now that privilege is asserted. Yes, I see nodding. Okay, thank you. Mr. Martinez, you have the floor.
Yes, thank you. No, that helps to understand what else was redacted in this document. It seems like some things that were beyond communications, and I'm glad we were able to establish that there were some additional items redacted, including draft policies and procedures. I just wanted to, this is offering to the leadership, again, in the spirit of Mr. Voland, the encouragement to take the necessary and aggressive steps. But let me go back to a word for the public. I recognize that the lack of information and understanding of different processes that are often complex can lead to fear and concern. But those things are different than justified claims of wrongdoing, impropriety. And so I think that's really important to recognize that I'm a promoter of literacy and municipal literacy and government understanding. So I think that's really great. But we're dealing with something that's a little crossed the line and in fact has taken some steps that moved into a place that is really concerning for what is the core here. Election integrity has to be a paramount value, and it's not a justifiable tool to say, because we believe that, because I have a value of election integrity, that I'll use unjustified claims and or spurious timing and coordination to create an argument of the undermining of election integrity. I think that's exactly the opposite of what we should be focused on. And I encourage the chair and the leadership to use whatever necessary tools that we have available to us to get cleanly to the bottom of this particular story and into the place where we move in legislative action to support the integrity of our elections.
Thank you. I'm going to pivot to Mr. Hurt. But briefly, I'm going to state at the last work session, the chief of staff on behalf of the mayor stated unequivocally that the mayor had no knowledge of this policy project. So that's all entered into the record. And I believe that we have some pretty thorough analysis that we're willing to go to bat with that states a policy that is set up that is illegally implemented, that doesn't have the work through up to the mayor, does not actually fall under the subject of that privilege. I'm not an attorney, but I'm going to hand it over to an attorney. Mr. Hurt, there were some questions about the validity of an executive session and the question of the privilege.
Thank you, Mr. Chair. So I'll address the last issue first. With regard to deliberative process privilege, the August 18th letter that was provided to members provides more detailed analysis, but essentially there's a strong argument that a deliberative process privilege would not apply to the requested documents, as at this point it appears to be undisputed that the communications and the underlying documents were created wholly apart from the established deliberative process as articulated in PNP 1-1. And with regard to the privilege log that Ms. Willoughby did provide, the reason it wasn't provided to the members is that the privilege log goes page by page and identifies discrete documents by page number. However, the documents, when they were turned over to the chair, were not in chronological order or any logical order I could decipher. I probably came from wherever the source was, so they were kind of all over the place. So when in reassembling these documents into a more usable format for the members, the privilege log was set aside. Unless there's a communication that includes Ann Helzer, the privilege being asserted is the deliberative process privilege. There are a couple of emails that involve Ann Helzer.
Literally just walked in.
And I won $1 million. So unless the redacted document has Ann Helzer either on the from or to or CC line, the only privilege being asserted is the deliberative process privilege. On the ones that include Ms. Helzer, I believe those, the attorney-client privilege is being asserted. With regard to the executive privilege, and I thank the chair for letting me clean this up. When I mentioned, executive session. When I mentioned executive session, I need to clarify that executive session has in code only 6 legal justifications for the assembly to meet in executive session. And part of the process is for us to lay a legal foundation to justify meeting in executive session. And at this point, I don't have any legal justification. There is no groundwork for us to, I don't have the ability to lay that groundwork, and I don't know what meeting in executive session would accomplish. So not say that that justification might not happen down the line. And that's kind of what I was saying when I alluded to executive session. But at this point, there is no justification that we can lay. And if we can't lay that foundation, I mean, I would strongly urge against the assembly even considering it, because it runs so contra to Open Meetings Act and the intent of how the assembly operates. So thank you, Mr. Chair.
All right, thank you. And briefly, I'm going to bump the queue. Ms. Elatel, previous question.
Thank you. Since we're on the topic of deliberative process privilege and Ms. Helzer has joined us, if you could join us up here. The Assembly sent an August 18, 2023 letter asking if, kind of doing our analysis of the claim of the privilege and asking if there was going to be any, if any additional documents going to be provided. And we didn't receive a response to it, and you were copied on that. Do you know if we're going to receive a response to our letter, either by the mayor or by the municipal attorney's office?
So yes, we did, through the chair, we did receive the letter, and there was a very, I thought, good analysis of the deliberative process privilege. The mayor is not here right now, and people have been away, so we haven't had an opportunity to go through the specifics, but I think my understanding was that we were willing to not address the issue of deliberative process at all and maybe just produce the documents. So that is on the table, and that is
Thank
likely
you.
a possibility. And that's why this has taken a little bit long, because rather than to address or debate whether the privilege applies, we figured we could just not apply it.
Thank
So,
you, Ms. Helzer. I
thank you.
appreciate that update. And since you came in a little late, we're working against a really tight time clock because we're looking at whether or not we need to make code change to the elections code, and our deadline has to be by the end of the year because then there will be an elections contest. So if you could at least confer with our council and legislative council to maybe provide a date by which we could expect those, I think that would be really helpful. Thank you so much.
And just to be clear, not an election contest, an election, an election contest in election parlance has a very specific meaning. But yeah, for people outside, it's a contest. For people inside, it's different. So I have a couple last comments. Ms. Braga, Ms. Brawley.
So thank you, Chair. I heard that this was first brought up in probably enough time, the USB removable storage device policy, in probably enough time to properly have put it in place. And it's concerning to me, as all of us, and this was brought up at the last meeting we had, the emails that are in our binder here where Mark Dahl is saying getting close, and Heather Holland is putting this policy on the intranet, and then the email where, wow, that's fast. I'll talk to Mark about your bonus. That all just looks so bad. It just, to me, that's something we really need to get to the bottom of. If this policy is a good one, let's properly put it in place. But to this email string the day of the election is really concerning to me.
I believe it's the day of the complaint. Yeah, not the election, but yes. Ms. Brawley.
Yeah, thank you. Just returning to the question of executive session, and I appreciate the reiteration that there are specific reasons why we are able to do that legally, and then in reference to the Open Meetings Act, because I think the principle and the law that we operate under is that public records are public, our deliberations are public, the actions of people acting in their official capacity are public unless there are specific reasons why they're not. And so, so setting aside questions of motive and questions of things that are not in writing already, I would just like to see the public documents that were done, which are, we're talking about emails and policies by people acting in their official capacity, because I think that's the story we're trying to get to. And setting aside all of these other questions about what the policy is, whether it's a good policy or not, it really is about what actually happened in writing in our public records that already exist that we are not being given access to. And fundamentally, that is the question. So I have no interest in an executive session because this is not executive session. This is in the public interest to understand what happened, again, by people acting in their official capacity. And that is what we are trying to get to. And until we can get there, and until there's some other justification why we can't see those things, that they're in our emails right now. They're not in my personal email. They're in the Muni email system. That is what we need to know.
Mr. Martinez.
Thank you, Chair. Just with respect to the actions potentially taken, I don't know the legislative actions, but I do know one thing. It was referred in the letter from, or it was referred in the letter from Mr. Dahl's attorney that said, because the Ombudsman had invoked the possibility of potential criminal allegations. So I just wanted to, I don't know where that lands within our spectrum, but from the public's perspective, if there are potential criminal allegations, I'd love to hear a little bit more about what that leads to. And is that something that is part of the ecosystem of accountability ultimately that may be beyond us, but is part of a process that we have to, that may be unfolding as well?
Okay, very briefly, Mr. Hess, we're running to the end of our time.
So the code says that the ombudsman may refer a matter to law enforcement, the courts, the police, the FBI, attorney general, district attorney, if he has a reasonable belief that there may have been a criminal act. So as I looked at this matter, I called the chief assistant attorney general in charge of the Office of Special Prosecutions. We discussed my concerns. I had looked at the state election codes, and at the completion of my inquiry, I had a reasonable belief that there may have been a violation of law. We're not criminal investigators. We don't make that determination. And that's where motive comes in. So I did provide the chief assistant attorney general with a copy of my report. I met with Ms. Helzer. We reviewed a packet of documents, which I dropped off to the Office of Special Prosecutions about a week and a half ago. Documents, videos, photos related to this matter, and they are reviewing it.
So a couple last points as we are out of time. We do have another work session. I believe that this is probably best asked to Ms. Helzer right now. Is Mr. Dahl still an employee of the municipality?
Just before this meeting, I spoke with the mayor. He is out at the moment. He's on leave, as I understand it. So I don't know where he's located right now. But he did indicate that they had discussed resignation and that he expected to get an answer at some point by the end of the day.
Okay, thank you. That's great. And we would welcome that information. Final questions. These are the questions the Anchorage Daily News editorial board has proposed. Who was involved in this scenario? What was redacted and why? Why hasn't the mayor spoken about the incident? When will the administration take action on Mr. Dahl? And without answers, how can Anchorage residents trust their government to do the right thing in the context of an election? And so with that, I just want to extend to the mayor an open invitation to come have a conversation. We are willing, ready, and able. It's painful. It's a difficult subject, but his chief of staff has asserted the mayor wasn't a party to it. So it should give him some protection in that conversation. With that said, Assembly leadership will be considering potential actions over the course of the weekend, and we may have a plan to propose on Tuesday. So with that, I'm going to adjourn this work session. Thank you.
We can start 5 minutes later on the next one.
And we will start in 5 minutes for the